Okay, welcome everyone to this sales lunchtime seminar. For those who don't know me, I'm David Erdos, and I teach and research data protection in the faculty, particularly EU and UK data protection. And therefore, it's my very great pleasure to welcome Eleonor Duhs, who has an incredible experience with GDPR, with negotiating it, with advising the government on Brexit, which is a big topic across the faculty and across society still. And she's now at Fieldfisher and is advising businesses and others on particularly data protection and the UK-EU data relationship, which is a really topical issue and a really important issue. So Eleonor is going to talk for about 40 minutes, and then there'll be the opportunity for questions to put to Eleonor. You're very welcome to put those questions as the presentation goes on. I don't tend to I'm not generally won't name check everyone, but if you particularly want to be anonymous, I think there's you can note that, or I think there's a button to say that. So the talk is going to be particularly on the trade and cooperation agreement, so absolutely topical, and particularly on the free flow of data globally, including outside the UK and EU's borders. So without any further ado, I will now pass over to Eleonor.
Thank you very much indeed, David, for that introduction. It's wonderful to be here, and good afternoon to all of you. The EU and UK Trade and Cooperation Agreement and the free flow of personal data, is it a solid foundation for data flows? So I'm going to take you through the structure of this talk first. So it's got three parts to it. First of all, I'm going to give a bit of context. So I'm going to look at the EU in particular, and a little bit as well at the UK data protection regimes, and how the free flow of data to third countries is affected under those relevant instruments. And I'm going to look at data adequacy, which is the mechanism that allows for the free flow of data from those jurisdictions to third countries. Next, I'm going to analyse the Trade and Cooperation Agreement, and in particular, the provisions that relate to free flow of data and data adequacy, and look at how that interacts with the EU regime in particular. And then finally, I'm going to come on to look at the UK's future policy on data protection and the free flow of data. And that's really central, really, to this post-transition period era, if I can put it that way, where the UK is wanting to strike trade deals with third countries, but also to enable the free flow of data to those countries to really encourage economic growth and trade between the UK and those international partners. And there's going to have to be a delicate balance struck here, really, between keeping data adequacy, EU data adequacy, and allowing that free flow of data from the EU to the UK on the one hand, but also conferring UK data adequacy on those third countries in order to enable that trade to take place. So those are the three components, as it were, of this seminar. So moving on then to the first section, looking at the context and the EU and the UK data protection regimes. In the EU, we have the General Data Protection Regulation, or GDPR, and I'm also going to touch on the LED, the Law Enforcement Directive as well. So those two instruments regulate, the General Data Protection regulates the processing of personal data generally, and the Law Enforcement Directive relates to the processing of personal data in the context of criminal offences and police cooperation, that sort of thing. But I'm going to focus, as I say, on the General Data Protection Regulation. So the form of the measure of the GDPR is interesting. Prior to 2018, the processing of personal data was regulated via a directive in the EU. And so all of the member states had their own national laws. And there was a sense when the EU looked again at this policy area that there was fragmentation. There was a difficulty really in enabling the flow of data in order, for example, to allow the single market to function properly, and that a regulation would actually create better harmonization of standards. So that's what we have now, a regulation rather than a directive. So the same legislation, the same measure applying right across the EU to regulate the processing of personal data. The legal basis for the GDPR is a new one under the Lisbon Treaty, Article 16 of the Treaty on the Functioning of the European Union. And it's interesting, I think, to look at the drafting of Article 16 and the drafting of Article 8 of the Charter of Fundamental Rights, which is the protection, the right to the protection of personal data. And there are really quite striking similarities in the way that the Charter and Article 16 express this protection of the right to personal data. So those are the foundations really of the GDPR, that Charter right and Article 16 of the TFEU. The other thing to note about the GDPR is that it has extraterritorial scope. So if you're processing personal data, perhaps you're monitoring data subjects in the EU, but your business is outside the EU, you will still be subject to those EU rules in the GDPR. So the GDPR has potentially global reach. I just want to touch on what's happened in terms of the way in which data, personal data is regulated, the processing personal data is regulated in the UK after the end of the transition period, so after the end of last year. So the UK essentially turned the GDPR into domestic law through the European Union Withdrawal Act 2018. So the GDPR became the United Kingdom General Data Protection, UK GDPR. So in many ways, it is exactly the same as the GDPR, has the same language and the processing of personal data, and in particular, the free flow of personal data, the transfer of personal data outside the UK and the EU. Those provisions look essentially the same at the moment, but there are some differences which I think are interesting. So the European Union Withdrawal Act 2018 didn't save the Charter of Fundamental Rights. That's no longer applicable in the UK. So we've got the basis for the protection of personal data in the EU being founded essentially in the Charter of Fundamental Rights, Article 8 of the Charter of Fundamental Rights. That instrument no longer applies in the UK. And I think it's going to be interesting to see whether that makes some difference in terms of how we approach this fundamental right in the UK as compared within the EU. So that's a bit of context on the instruments themselves. And now I want to look in a little bit more detail at how the free flow of data from the EU in particular, but as I said, the provisions are essentially the same in the UK as well, but the free flow of data from the EU, how is that done under the GDPR? Chapter 5 is the relevant chapter, and there are three main ways that you transfer data out of the EU in accordance with the GDPR. So the first is adequacy decisions. So I mentioned adequacy at the start of this talk. This is a really important mechanism that allows for the free flow of data without businesses having to really do anything else. If you have an adequacy decision, and that requires the European Commission to look at the data protection regime in the third country to which the data is being sent, as well as its adherence to the rule of law, its international obligations, these are all looked at in detail by the European Commission. And if the Commission decides that the country in question has an essentially equivalent standard of protection to the standard of protection in the EU, then an adequacy decision is conferred. There are very few adequacy decisions actually that the EU has conferred, only 12 at the moment. Some are on countries like Uruguay, Argentina, Japan. Others are on certain territories within a country or potentially a particular sector. So for example, with Canada, there's an adequacy decision which applies to commercial entities in Canada, but only 12 adequacy decisions. Next, standard contractual clauses. So these are signed by the data exporter in the EU and the data importer in the third country. These are the most usual way to transfer data out of the EU. So these model clauses are used and they're signed by both parties. And again, the standard of protection that is required for sending data using standard contractual clauses is the same as for adequacy, this essentially equivalent test. And I'm going to look in a bit more detail about how all of that works in practice, as I advise on this a lot. And there are real difficulties, I think, for businesses in complying with these standard contractual clauses, although they are the most usual way to transfer data. And finally, derogations. So if you've got a sort of one-off situation where you're just sending data for a particular purpose, so if someone's booking a holiday abroad or something like that, a derogation can apply, but really they're not used very much. So standard contractual clause is the main way to enable data to leave the EU in accordance with the GDPR. So looking at these methods in a little bit more detail, so the Commission, as I said, assesses the level of protection in the third country, looking at a number of factors which are set out in the GDPR. And the test they're applying is, do all of these elements taken together mean that the protection of personal data in this third country will be essentially equivalent to that in the EU? So the sort of matters that the Commission will take into account, they're set out in Article 45 of the GDPR. I haven't done a comprehensive list, but this is just to give you a sense here. So the third country's laws and rules governing data protection, the relevant legislation concerning public security, defence, national security and criminal law, respect for the rule of law more generally, fundamental rights, access to personal data by public authorities. That's really worth highlighting because this is where adequacy decisions in the past have come unstuck and been invalidated. So this is an area of real difficulty. The rules for onward transfer of personal data. So if you've got free flow of data to a third country, but then the onward transfer isn't sufficiently protected, that would be problematic. So the rules for onward transfer from that third country to another country are very important in terms of making sure that protection is essentially adequate, essentially equivalent, sorry, to that in the EU. And finally, the international commitments that the third country has entered into. So that gives you a sense of what the Commission's looking at when it's making these adequacy decisions. There are also further criteria which were introduced by the Commission in 2017, looking at which countries it wanted to engage with relating to adequacy. So these are much more to do with trade and much more of an emphasis on that. So the extent of the commercial relationships with the third country, whether there's a free trade agreement being negotiated, the extent of the data flows to the third country, the role the third country plays in the field of privacy and data protection, and finally, the overall political relationship with the third country in question. So that's really looking at who is going to be, whose system is going to be, or legal system is going to be analysed in relation to data protection with a view to adequacy. And as I say, very few adequacy decisions actually in place at the moment. In terms of EU to UK data flows, it's just worth mentioning that in February of this year, the Commission published 2 draft decisions, one in relation to adequacy under the General Data Protection Regulation, GDPR, the other under the Law Enforcement Directive. So these decisions confirmed that the UK was adequate in terms of its protection of personal data. Unsurprising, I think, had the Commission decided that the UK didn't have an adequate level of protection for personal data as a departing member state, that would have been extremely problematic, because if a departing member state isn't adequate, what other territory or country could be adequate, really? So I think there was some speculation, is the UK going to receive adequacy? I think it was expected. Otherwise, really, the bar would have been set impossibly high for adequacy. But the UK's adequacy decision, interestingly, is time limited, so it's going to last for 4 years only. It's going to be closely monitored by the Commission but also I think generally there's going to be an awful lot of interest in it and in what the UK is going to be doing in terms of its data protection policy, and whether that means that the protection of personal data in the UK is moving away from that essentially equivalent standard of protection. So I'll come on to talk about that in a little while, but I think there's going to be a lot of interest in the UK's adequacy decision. Adequacy is really problematic. And the reason for that is that twice now, adequacy decisions in favour of US companies, so this is a sector-specific adequacy decision, have both twice, the Court of Justice of the European Union has invalidated adequacy decisions relating to the US. Both cases brought involving Mr. Max Schrems, who's a privacy activist, and the first involved the safe harbour decision, so an adequacy decision, which, as I say, related to US companies, so enabling the free flow of data from EU entities to those US companies. The sticking point, I don't want to go into too much detail on the cases, but it really essentially was that point about the access by public authorities to EU data once it was in the US. And we had a similar outcome last summer in Schrems 2, where Privacy Shield, which was the successor instrument successor adequacy decision to Safe Harbour, was also invalidated by the Court of Justice of the European Union. And I think it's fair to say that I think particularly Safe Harbour, when it was invalidated, it was extremely difficult for businesses. It took about 9 months to do a repapering exercise when adequacy was lost, to put in place standard contractual clauses. So that's that second mechanism for the transfer of data. So really, I think there was a sense that businesses were left sort of having to pick up the pieces when adequacy was lost, and that's obviously happened again last summer with Privacy Shield. So there is a sense, I think, that adequacy, although it's in some ways the preferable transfer mechanism, because you don't have to do anything further in order to transfer the data, you just rely on the adequacy decision. The difficulty is that it does seem to be unstable. I want to talk about the Schrems 2 case as well in relation to the standard contractual clauses, because, as I say, that's the second transfer mechanism. That was the one that people turned to when Safe Harbour and Privacy Shield were invalidated. That is a valid transfer mechanism, but it has become extremely problematic. And in Schrems 2, the Court of Justice looked at standard contractual clauses and said that essentially the way in which we thought they worked wasn't the way they worked, because before you would have the standard contractual clauses, the exporter would sign, the importer would sign, they would go into someone's desk, quite frankly, and no one would really think about them anymore. But that has all gone. That way of simply signing the clauses and thinking, right, we can transfer the data from the EU to a third country, no longer applies. So now what we have is a much more detailed and onerous process that has to be gone through. So firstly, a business that wants to rely on standard contractual clauses to send data from the EU to a third country has to look in detail at the standard contractual clauses. Can we really comply with all the requirements here? So just signing them isn't nearly good enough. A detailed look has to be undertaken. And next, the Court of Justice in the Schrems 2 case said, you also have to look at all of the factors that the European Commission looks at when it confers adequacy on a third country or territory or sector. And so all of these factors which I've set up here will be relevant. So the business itself has to look at the third country's data protection laws. It has to look at its national security legislation, its respect for the rule of law, its international commitments. And that is really setting the bar so high that for most companies, that is just not realistic to actually be able to do a meaningful assessment of the third country's rule of law in order to decide whether it's adequate. I think there was a sense that perhaps that one could just assume that third country wasn't adequate and move on to look at other measures, which is that third element. But no, the European Data Protection Board, which is the group of EU regulators that meets and sets out guidance for companies to follow, says no, you have to actually do this mini adequacy assessment. So a huge amount of resource is now having to be devoted to this. And I think I've put on the slide a system in crisis ? Because really there is a very strong sense that this is a completely unrealistic requirement on companies. If your country, your third country, doesn't meet the essentially equivalent test, it's not adequate, which for the most part I think will be the case, then you have to adopt other measures to protect the data so it reaches that essentially equivalent standard of protection when you're sending the data as you have with this adequacy process. So you look at technical, contractual, or organizational measures which might provide those essentially equivalent protections. And I just want to mention how these work, because again, these are extremely difficult to comply with. So the European Data Protection Board, in its draft guidance, although we think probably that the final guidance is going to look quite similar, the European Data Protection Board has looked at 3 different technical methods, amongst others. And I just want to show you how difficult those are, because encryption, pseudonymization, where you take out the identifiers and keep them separately in order to enable the data to be sent without those identifiers in place, which is a way of protecting the data, or split processing, where you send the data to different entities outside the EU who can't then put the data back together. Those are 3 methods of protecting the data which are suggested in the European Data Protection Board's guidance, but which are really, really difficult to comply with. So for encryption, the cryptographic keys have to stay in the EU or in an adequate third country, says the European Data Protection Board. That's unrealistic because in the life cycle of most data, it has to be decrypted at some point in the third country. Otherwise, it rather defeats the purpose of sending it in the first place. So for many clients, encryption isn't the answer, particularly if the cryptographic keys have to remain in the EU. Pseudonymization is also problematic because you have to take out the identifiers before the transfer takes place, leave them in the EU or in a third country, and the exporter is the only one who should be able to re-identify. And also analysis has to be undertaken as to whether a public authority in the recipient country could work out whose data is being processed. And again, in most cases, the life cycle of the data does require those identifiers to be put back in at some stage in order for the transfer to make sense in the first place. So that technical measure, again, is really problematic. And the split processing as well is problematic because you have these 2 separate importers who can't put the data back together. But again, for most practical data protection or data transfers, you really do need at some point to have those identifiers in place. So that just shows how difficult data transfers and the free flow of data from the EU are at the moment for most businesses. And now I'm going to look at the Trade and Cooperation Agreement and how that deals with the free flow of data and cross-border data transfers. The first element to mention, which I'm just going to touch on briefly, is that the Trade and Cooperation Agreement contained an adequacy bridge. What that did essentially was to say that the UK was adequate for transfers until such point as the adequacy decisions, which is currently still in draft, were put in place. So that lasts for up to 6 months from the end of last year. I think, as I say, that there's no real question mark in my mind that the UK is going to receive those adequacy decisions and they'll be finalised shortly. But the reason for the adequacy bridge was simply that negotiators ran out of time. The other thing now I want to focus on is the provisions in the Trade and Cooperation Agreement, which are in many ways exceptional. They're exceptional because they are at odds with the EU's normal position on the data protection provisions in trade agreements. They give, I think, a greater stability to UK adequacy as compared with other adequacy decisions, which don't have these sorts of provisions, which really assist, I think, in providing political solutions should there be difficulty or challenge or the potential for a UK adequacy decision to be invalidated. So I think that's remarkable and worth thinking about and looking at in more detail. I think that they create tension between the GDPR and the provisions in the Trade and Cooperation Agreement, and potentially tension as well between the EU institutions and the Partnership Council, which oversees the Trade and Cooperation Agreement. So to start with the standard position on free trade agreements and the EU's position in relation to those and the provisions it normally has in place for trade agreements. So prior to 2018, there were no provisions on cross-border data flows in EU trade agreements. And the reason for that is that the EU sees the protection of personal data as a fundamental right, and the view was we don't negotiate on fundamental rights, so we don't put in provisions relating to fundamental rights in trade agreements because they're not up for discussion, essentially. That position changed somewhat in 2018, so there were some new standard provisions which allow or support the free flow of information whilst safeguarding fundamental rights, safeguarding the privacy of citizens. So the two core components of these new standard provisions are firstly that they prohibit specific types of restrictions on cross-border data flows. So they don't have a broad commitment to allow cross-border data flows, but they do prohibit specific types of restrictions. And the second core component is that they carve privacy measures completely out of the scope of the agreement. And that reflects that policy position that we don't negotiate on data protection, and our data protection regime shouldn't be subject to any other provisions in free trade agreements. So just to summarize what these standard provisions do, so they promote cross-border data flows but they also ensure that the EU unconditionally preserves its autonomy to regulate in the area of data privacy and essentially protect the GDPR so it's immune from challenge. What's really interesting in the Trade and Cooperation Agreement is that only part of that standard drafting has actually ended up in the treaty. So we've got the standard wording on cross-border data flows. So cross-border data flows shouldn't be restricted on a number of different grounds. So one example here is shan't be restricted between the parties by a party requiring the localization of data in the party's territory for storage. So that provision is unremarkable and standard, but the next provision which I wanted to highlight really is quite remarkable because contrary to the usual standard wording from 2018, which sets out that data protection is a fundamental right, that reference isn't there in the Trade and Cooperation Agreement. And secondly, this extract here, which carves out the EU's data protection framework from the Trade and Cooperation Agreement, has also not found its way into the drafting in the Trade and Cooperation Agreement. So this protection for the EU regime that each party may adopt to maintain safeguards it deems appropriate to ensure protection of personal data and the adoption and application of rules for the cross-border transfer of personal data, that carve out isn't present. And commentators have said that the absence of that carve out means that the EU is going to have to pass some strict trade tests in order to justify its measures. So that protection of those GDPR provisions isn't there. So that really is interesting, and I think creates something of a tension between the GDPR then and the TCA, the Trade and Cooperation Agreement provisions on the protection of personal data and the free flow of data. The next tension, I think, is really fascinating as well. So I mentioned earlier about the Partnership Council, which oversees the trade and cooperation agreement and how it's conducted, if I can put it that way, how the relationship is between the parties in the context of that agreement. So this provision here allows the Partnership Council to make recommendation to the parties regarding the transfer of data covered by the agreement or any supplementing agreement. And this is really interesting because if there was a sense that the UK's adequacy was somehow, well, possibly subject to challenge, or there are question marks over it, then the Partnership Council can come in and provide some solutions and possibly head off that potential loss of adequacy before it happens. So I think in contrast to what we've seen in Schrems 1 and Schrems 2, there is real possibility here for the Partnership Council to provide some extra stability for that adequacy decision, but potentially also to create some tension between the European institutions, possibly even the Court of Justice, finding that the adequacy decision is invalid on the one hand, and the Partnership Council providing that political forum in which to deal with that issue. So potentially it's not going to be like Schrems 1 and Schrems 2, where it's businesses picking up the pieces, but we get a political solution through the Partnership Council to any potential loss of adequacy. And I think this is even more striking, actually. This is in the context of law enforcement. If adequacy is lost, if there are deficiencies that have led to a relevant adequacy decision ceasing to apply, then this provision comes in. It anticipates that a party, presumably the EU in this instance, will suspend potentially or look to suspend certain provisions of the law enforcement aspects of the trade and cooperation agreement. But then the Partnership Council is able to come in and look at ways of allowing the party who has notified that suspension to either postpone its entry into effect, reduce its scope, or even withdraw it, which is really quite striking. So you could have a situation where the Court of Justice has said that the adequacy decision under the Law Enforcement Directive isn't valid, but the Partnership Council can come in and even look at the possibility of the parties withdrawing that suspension and allowing those data flows to continue. So I think there's some good arguments that can be used here. And obviously, we haven't seen how this treaty is going to actually sort of take shape because it's in such an early stage, but there is real possibility here, I think, for the UK adequacy decision to be more stable and for these political solutions to be found to enable the free flow of data to continue in a way that we didn't see with Schrems 1 and Schrems 2 and Safe Harbour and Privacy Shield. So that's a little bit on the Trade and Cooperation Agreement and those provisions on personal data and free flow of personal data. And then the final component to this talk is looking now forward at the UK's future policy on the free flow of data and on trade and digital trade in particular. So this slide contains an excerpt from the National Data Strategy, which was published in draft at the end of last year, and it sets out a vision for the UK as a world leader in the digital space and in the promotion of the free flow of data across borders in order to create economic growth. So there are various missions here that are set out in the National Data Strategy, unlocking the value of data across the economy, transforming the government's use of data, but it's this fifth mission here, championing the international flow of data, which I wanted to highlight. So just to look in a little bit more detail about what that means, we see here that the UK is intending to come up with new ways to transfer data internationally, so new and innovative mechanisms, facilitating the cross-border flow of data and removing unnecessary barriers to international data transfers. And then a really important aspect of the policy as well, this idea of UK adequacy. So the UK conferring adequacy decisions very much like the EU does but on global partners to promote trade and the free flow of data to and from the UK. So a little bit more detail on that. So what I've set out here is the relevant provisions in the legislation. So Article 45, the UK GDPR, looking essentially the same as Article 45 of the EU GDPR, which we looked at before. So all of those factors like the rule of law, the protection of personal data within the jurisdiction, all of those will be factors that the UK looks at, and the Secretary of State under Section 17A of the Data Protection Act 2018 will be empowered to make adequacy regulations conferring adequacy on third countries. Is there going to be a different approach here? Obviously, the legislation, the broad framework is the same, but from what one sees in the National Data Strategy, there is a suggestion, I think, that this is something that the UK is going to be doing a lot more of, perhaps than the EU has done with its 12 adequacy decisions, and really using adequacy as a means of strengthening economic ties with third countries. So a really interesting potential departure here really for the UK, and being agile, I think is the word that's often used, and really pushing that agenda, that international flow of data. Coming on to standard contractual clauses, those are also part of the UK's regime. So that's Article 46 of the UK GDPR, Article 46 of the EU GDPR, looking more or less the same. But then under the UK regime, there's a power for the Secretary of State and for the Information Commissioner to bring forward new standard contractual clauses. And so I think one of the questions which is interesting is to consider what happens to that Schrems II approach, that Schrems II case law that we looked at, that three-stage test of having to look in detail at the standard contractual clauses, having to do the mini adequacy assessment of the third country, and having to look at these technical measures, which quite often really aren't practical for the transfer of data. So the Schrems II case under the new UK GDPR and the European Union Withdrawal Act 2018 is retained in our domestic legal system as retained case law. But the interesting thing about retained case law is that it applies to retained EU law, as it's called, so it applies to the UK GDPR. But if you're bringing forward new mechanisms, such as new standard contractual clauses, it becomes a question of the intention of those new clauses, the intention of ministers in bringing forward those new clauses, as to whether or not the old retained case law applies to the interpretation of that measure of those new standard contractual clauses or not. So that's section 6.3 and 6.6 of the European Union Withdrawal Act 2018. So it's very possible that ministers could decide that with these new standard contractual clauses, they shouldn't be interpreted as retained EU law. They should be interpreted as new domestic law, and therefore the retained case law no longer applies to them. So Schrems II potentially wouldn't apply if that was the intention of ministers to the new standard contractual clauses. So potentially that sweeps away some of those really significant barriers to the transfer of data that companies are having to deal with at the moment. But then the real issue then, do we have a solid foundation, you know, at the end of this exploration of data adequacy and trading cooperation agreement? Do we have a solid foundation for the transfer of data? I think under the trading cooperation agreement, we do have something which gives some stability, I think, to UK adequacy, which is that forum for political dialogue, the Partnership Council being able to make recommendations to the EU and the UK, and hopefully to head off difficulties which may emerge, challenges to the UK's adequacy decision. But if the UK adopts a policy of conferring adequacy on third countries and perhaps adjusts its own regime, so no longer has the Schrems II approach to the standard contractual clauses, thereby enabling data flows, then there could be a price to pay, which would be the risk that any data adequacy conferred by the EU on the UK could be lost. So that brings me to the end of this this talk. Here are some references. I will get the slides sent round if you wanted to have a further read of some material. David's done an excellent article covering these issues, which I highly recommend. So thank you very much.
Thank you very, very much, Eleanor, for a really, really rich presentation with so much food for thought in actually many, many different areas. Well, I have a lot of questions already, but that one question has already come in, and by the way, do keep the questions flowing.